Hey everybody, now I'm going to do a real quick video on police powers because I was asked to expand on it just a little bit. And so what I've decided to use is to use the Ohio Jurisprudence Volume 16, which is under constitutional law, and I'm going to read a couple things. Under Section 302 of their purpose of police powers, that's what Section 10 is, subsection 302 to Section 358. And this is the current edition, the third. It says that the state police powers is inherent in sovereignty and is invoked by the courts to sustain legislation that is passed to provide public health, moral safety, and welfare. That's something to be noted. So, according to the courts of Ohio, the police are there to enforce legislative rule. Not the sheriffs, not the people, but some state power. Okay? It then goes on to say that one principle, this is subsection 303, one principle involved in the police power is expressed by the well-known maxim, salus populi suprema lex est. The welfare of the people is the highest law. The foundation of police power is that of the governed. Promulgating laws to guard a society's health and safety is among those legitimate police powers inherent in government. The police power is the right of the self-preservation and self-protection on the part of the community, and its exercise is justified by the necessity of the occasion. Now, they go on to say that police powers are not particularly defined, that they are kind of ever-evolving and amorphous, because, they don't really want to limit them. And then we get to, statements such as 307. Subsection 307, it says the police power is an essential and vital attribute of sovereignty. It is to the state as to the individual the first and natural right. So they're trying to say that the state has the right to an armed police force that is appointed by the state itself. It's not elected. Again, these are points to be made because what they're actually telling you in the Ohio jurisprudence by their own corporate judiciary, that they have basically see the police powers as the ability of the state to enforce the legislative law. Now, let's break it down here. This is the most key section pertaining to police powers. In that, it says it's subsection 309. So this is Ohio Jurisprudence, 3rd edition, volume 16, page 422, subsection 309. It says the term police powers is a judicial invention, and there are citations. Citation 65 says Myers v. City of Defense, 67 Ohio. There's a whole bunch of them. There's like 10 or 15. And so by multiple case citations, they're telling you that police powers were invented by the judiciary. They are not of a constitutional nature, okay? The term, and this is still in subsection 309, the term is not found in the Declaration of Independence, the Federal Constitution, or the Ohio Constitution. So right there in Ohio jurisprudence, in the state of Ohio, they are telling you that the judiciary created the police powers with the specific intent to enforce legislative statutes. Okay? That is 100% extra constitutional. And where that can be found and proven that it's extra constitutional is in a case Martin v. Hunter. And it's 14 U.S. 304, and I believe that this was in 1816. Now, Martin v. Hunter is a very important case that's never brought up. I think that I found it doing research on the Slave Acts. And it talks about the extension of powers versus the expansion of powers. And so when that happens, the extension of powers is constitutional. The expansion of powers is not. And Martin v. Hunter talks about some key phrases, and that the Constitution is literally to be, it's a literal translation. You're not supposed to put more into it than there is there by the wording. The words were carefully chosen by the framers of the Constitution to be explicitly read in the way that they are. And, for example, the first example of that is in the third article of the Constitution. It says that the first section declares that the judicial power of the United States shall be vested in one Supreme Court and in such other inferior courts as the Congress may, from time, little c Congress, not big C Congress, may from time to time ordain and establish. Now, the second section declares that the judicial power shall extend to all cases in law or equity arising under the Constitution, the laws of the United States, and the treaties made or which shall be made under their authority, in all cases affecting ambassadors, other public ministers, councils, yada yada. So the word shall extend was used, not shall expand. Okay, that's a very important distinction, because then this case goes on to talk about the 6th article of the Declaration, which says that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereof, anything in the constitutional laws of any state to the contrary notwithstanding. So, Martin v. Hunter says to every judiciary of every state that the Constitution says you can extend the grant, you may not expand it, and that all actions of judiciaries, even the judiciary in the states, which have unconstitutionally, by their own admission, created police powers for the purposes of enforcing the legislative statutes, are strictly forbidden by the language of Article 6 of the Constitution. So, it goes on to say that in the beginning of this case, it says the Constitution of the United States was ordained and established not by the states in their sovereign capacity, but empathetically, as the preamble to the Declaration, the Constitution declares, by the people of the United States. There can be no doubt that it was competent to the people to invest the general government with all the powers which they might deem proper and necessary, to extend or restrain these powers according to their good pleasure, and to extend them as paramount and supreme authority. So, if the federal Constitution says that the judiciary may not expand the grant, and that it is unconstitutional for the judiciary to expand the grant, and by their own words, in the Ohio jurisprudence, they have admitted to having expanded the grant to create police powers, that is why police powers are unconstitutional. So, the issue with police powers being created is, as I told you, post-Civil War, there is an act called the Bankruptcy Act of 1879, where the judiciary used police powers to bring people in to force bankruptcies on them at gunpoint. That's in it. That is in the act. So, the United States state judiciaries, after the federal government was laid vacant, gave themselves the power to use armies. Okay, now mind you, the judiciary is what cooed us in the Civil War. So the same bar union came in and gave themselves the extra constitutional capacity of an army, that they come at you as police. And it is 100% squarely unconstitutional by all means by the Articles of the Federal Compact. And so if the state judiciary continues to use the police powers to oppress the people, they are squarely continuing to operate de facto. There are institutions in the common law that were granted to the people in the 4th branch, the people who gave them the grant of law to be states, to be the federal construct, and to create and give the judiciary its grant. They have instruments in the 4th branch called the grand juries. The de jure common law grand juries, as I told you, are elected in the sheriffs and the militia of the regions. The only reason the states would need, as a judiciary, to create independent powers which expanded the grant of the judiciary, not the executive branch, not the legislature, was so that the judiciary, which had been cooed, could continue to enforce its coup and its oppressions upon the people through police powers. Now, if you've if you've listened to my conversation about municipal powers, you will understand why a coup of the judiciary is so significant, because the judiciary is what keeps the municipal corporate powers of the state from impressing or oppressing tyranny upon people through forced corporate jurisdictions. So, after the Civil War, the judiciary, which cooed the government, expanded their grant to give themselves an army. And then, by removing that checks and balances, the states, which had been couped, again through the bar union, by infiltrating and co-opting the executive and legislative branches, which they run right now, they were able to give municipal corporations, which are inclusive of courts, city governments, and any agents of state, that gave municipal corporations the capacity to force you in their jurisdiction in contradistinction to the Constitution of the United States. It's a paradox that's very difficult for people even learned in the law to understand. It's especially difficult if you're an attorney and you've been miseducated in the law. But it's even difficult for people who are in the law and study the law, because they have created a two-front war where they both vacated and couped the judiciary, which was the last bastion of checks and balances, and they've basically laid the fourth branch of government vacant by neutering the sheriffs, by trying to scatter the militias, because the militias were targeted and said they were terrorists. And they've also done away with the common law grand juries by not affording the people the costs, the monies to run the open elections where such things are held, so that people can be duly elected into the position. See, that's a difference. In the republic construct of the United States, or the States of America United, the people elect their sheriff and, again, their grand juries. In the legal, civil construct of foreign coup, everything is elected. The police powers are controlled by an elected official. Non-elected official, appointed official. The judiciary, though they are elected, they're all elected from the same union. And I bet if you even tried in certain states to run for office, they wouldn't let you. For example, in the state of Ohio, they're trying to tell you have to be a bar member union to even bring a claim, even a habeas corpus claim. That's an utter coup of the judiciary. So this is hopefully a shorter video that touches upon some facts that people need to know, and that show you how police powers in themselves were inherently designed as an instrument of coup. And if you're a policeman, I'm not saying you're a bad guy. What I'm telling you is you've been lied to about who you serve. You may, in your heart, serve the people, but your master is a corporate state that was couped a long time ago, and that does not serve the people, because one union is running the world. And it's the same union that serves the international bankers. It's the same union that controls the federal government. And so the proof is in the pudding that by their own terms, police powers are extra constitutional. And by the old judiciary, before the Civil War, it said that the expansion of such powers are unconstitutional. So, there you have it in summary. I hope that helps.